won't go. You're Jenny Penny to more. Oh, madam, alone, if I see a jail. And Shelly, oh, my coming, I don't feel you won't go. You're Jenny Penny to more. Oh, madam, alone, if I see a jail. And Shelly, oh, my coming, I don't feel you won't go. You won't go. Mẹ́tọ́ mi ní abẹ́ òfin ìwọ ń kọ́ yẹn jẹ́ ní fẹ́ni tí o mọ̀ o kò má dá ọlọ́run ò nífẹ̀ẹ́ sí ọ̀yẹ́ o èèwọ̀ ni. Mẹ́tọ́ mi ní abẹ́ òfin ìwọ ń kọ́ yẹn jẹ́ ní fẹ́ni tí o mọ̀ o kò má dá ọlọ́run ò nífẹ̀ẹ́ sí ọ̀yẹ́ ẹ̀ṣẹ̀ ni. Ìrònú ní fẹ́ni tí o ní lákòókò ohun tó ní tẹ́lẹ̀ omi ò ní o ìwọ kọ́ ọlọ́run tó fi kádàrá dé ẹ o màmá ní. Ọlọ́run tó fi kádàrá pé ẹ o màmá ní ọpẹ́lẹ̀ yẹn kò fọ́lá ẹ̀dá o kò lè pẹ́ mo lágbára mo wà nínú nǹkan mo lè pàṣẹ mo lọ́wọ́ màá yan tálíkà jẹ́ o ìtàlí oríkò tẹ́ni bá ti tẹ̀ o àtẹ̀gbé iṣẹ́ ẹranko nínú igbó màá ní ẹ tí ìwé ewúrẹ́ ó tó jẹ wọn ò lẹ́bi èyí náà kí ó fà á yá o kò lẹ́jọ́ ẹranko lẹ́ni tí wọ́n yàn jẹ́ o tí ò lè dún káwá lẹ́ni tí ò tí ì ní mo sọ pé ẹni tó ní ọ̀pẹ́ẹ̀sì mi ò lè dá owó tí yóò bá tó lọ́hùn-ún màmá ní àwọn bàtà rẹ́mọ́ díjẹ́ yìí Yorùbá jáyọ̀ pọ̀tọ̀ kórìíyá èdè máa dún ẹsẹ̀ kan mi ní sùúrù yìí kò gbọ́dọ̀ mi ò lè dá owó tí yóò bá tó lọ́hùn-ún màmá ní àwọn bàtà rẹ́mọ́ díjẹ́ yìí nítorí pé mo mẹ́tọ́ mi àṣàkọ ọmọ mi ní ọ̀dẹ́
Good everyone. You are welcome to the program which is known as Know Your Right Under the Law, being brought to you by Abdullahi Adebayo Abdurrauf. And on the program today, I shall be explaining an interesting topic that has been scheduled to be explained last week. And we are unable to come to the program last week because of what transpired, because of what happened. It's even a good thing that occurred. We were on the street of Kano disseminating legal awareness to the people there, and that was the reason why we were unable to come live. And you know, we are doing this online, and we decided to join. I decided to join my colleagues at the Bayo University Law Clinic to explain what the law has said to the people, and at the same time how they can seek redress under the law if any of their rights has been violated. That was the reason why I was not able to come last week. And because of this, I hereby tender my unreserved apology for not being here, and at the same time not giving you any notice before the program won't be commenced. This program is brought to you with the this program is being brought to you by Ajisebioyo Online Radio and TV and Abdullahi Legal Academy. And Abdullahi Legal Academy is an initiative that caters for the dissemination of the knowledge of law, especially the rights that we have under the law and how to seek redress for this right, and at the same time organizing result-driving law tutorials for law students across various faculties of law in Nigeria. And Abdullahi Academy at the same time is doing so many things in order for us to be able to achieve these two aims of ours. This is one of our programs. This is our radio legal awareness program. The topic that we shall be explaining here today is landlord versus tenant, where tenant refuses to pay his rent. And you know, whenever the tenant refuses to pay his rent, there has always been a kind of a battle between the landlord and the tenant, because how will you not pay your rent? Was your father the one that built the house for me? Why won't you pay your rent? Mr. Man, come and pay your rent. And the tenant might be, yes, I don't have money to pay, and because of this, I won't pack my load out of the house. Whatever you want to do, go to hell. And we'll be like, wow, so you are still telling me this? I give you my house to be living, and you are now telling me that you won't pay me rent? Wow. So I didn't mean that this is how this is how those people that has come before you are doing. Will you be able to come to this house? You are ungrateful. You know, all this kind of argument that usually come between the landlord and tenant most of times when the tenant refuses to pay is rent. And do not forget, when I was explaining previously, I made mention when I was explaining, especially when I was defining who is a tenant, I made mention that a tenant who owes over, when the tenancy agreement expires, the person whose tenancy agreement has expired is still a tenant in that house which is living. Do not forget, and the landlord cannot do anything until he does something under the law, which is required of him to do at a particular moment in time. So now, will there not be a contradiction between the right? Will there not be a violation of right of tenant as against that of landlord? Because the landlord is entitled to collect his rent, and here is is a tenant who want to refuse to pay his or her due rent. And the law is now saying that even though the person has not paid his or her due rent, he can still stay in that house because he is a tenant. Will there not be any kind of violation of right on behalf or in respect of that of landlord? Yes or no? If it is yes or if it is no, we start explaining here today. Now, if a tenant refuses to pay his landlord his due rent, the tenancy agreement has expired and he ought to renew the tenancy as usual, and he refuses to refuse the tenancy. Maybe he has any excuse or not. Even though he has excuse or not, that doesn't count under the law, because as a tenant, you must pay your landlord your due rent. And as a landlord, you are entitled to your rent at any due time that it is meant for you to recover it from your tenants. Now, what are those things that the law has told the landlord to do if this should occur? The first thing that these things are categorized into two: the ones that the landlord must do and the one that he must not do. When you're talking about law always come with the word must. Must. This is what you must do, not this is what you can. No, you don't approach the law with the mind of you can or you cannot. No, it is what you must. The law is commanding you. It has coercive force. It has coercive power. It is commanding you. These are what you must do. When the tenant refuses to pay his due rent at a particular moment in time when he is supposed to pay the rent. Let's now take for an instance. Now, okay, let me not bring an instance into this matter at this earlier time. Now, the first thing that the landlord must not do is that he must not resort to self-help. He must not resort to self-help. I've explained this one in the last lecture. The landlord is not allowed to go into the house of his tenant and start packing out his loads. The landlord is not allowed to go onto the roof of his tenant and start removing the roofing sheet, so that when rain is falling, it can destroy the property of the tenant. At the same time, the landlord, the tenant will be fed up and start packing out his out of the house because of the wickedness of the landlord. No, the landlord cannot just go into the house of his tenant and start shouting on him or her, you are the debtor, come and pay my money. All those kind of things that people usually do when they see that the person is indebted to them. No, the law does not allow the landlord to do such. There has been several cases that have been decided by the court where the landlord has resorted to self-help and the tenant sued the landlord into a court of law. And at the end of the day, the judgment favored the tenant against the landlord over his house. And the court later made the landlord to suffer for his action. Because of what? Because he resorted to self-help. You cannot resort to self-help if your tenant refuses to pay his due rent to you. This is one of the first things that you must take notice of. Now, if you want to approach the law as it should be approached, the first thing that should be considered is that of notice. Notice the type of tenancy that is in question will define the kind of notice that is to be issued to a tenant at any particular moment. And let's take for instance, there are many types of tenancy here that I will explain here today, and what period of time has been stipulated by the law for a tenant for a landlord to give a notice to such a tenant under that type of tenancy for that kind of notice to be effective and at the same time to be acceptable by the law or under the law. There are many types of tenancy. We have that of tenancy at will, we have that of statutory tenancy, and we have that of periodic tenancy. Periodic tenancy is that kind of tenancy where the tenant is paying the landlord rent, maybe weekly, monthly, quarterly, or yearly. That is periodic tenancy. And statutory tenancy is that of one, I have explained one in the past, is that of one if when that is that of one that come into force, that occurs when the tenant the tenancy agreement has expired, but he still refuses to leave that premises and at the same time refuses to pay another rent. At that particular moment in time, he is a statutory tenant. And the third one is that of tenancy at will. Tenancy at will is somehow similar to that of statutory tenant, but the only thing is that the tenant under tenancy at will stay in that property after his tenancy agreement has expired, but he has the consent of the landlord to be staying over that premises at that particular moment in time. So that of statutory tenancy does not even need the landlord to give him or her consent, but that of statutory tenancy at will, no, he has obtained the consent of the landlord before he holds over after his tenancy agreement has expired. And that means that that tenancy is subjected to the will of the landlord. Now, in the case of a statutory tenant and that of tenancy at will and that of periodic tenant, how are they going to be given or to be issued notice? How are they going to be issued notice whenever the tenancy agreement has expired and the landlord is willing to recover his premises from the tenant? That of tenancy at will and that of statutory tenant, they just require 7 days notice. 7 days notice. After this has expired, they need 7 days notice. And for periodic tenancy, before the tenancy agreement is expired, you must have issued the quit notice prior to the expiry of that of what of the tenancy agreement. Let's for instance now, in my house, I rent a house and I'm a yearly tenant in that house, and my landlord wants to recover the premises from me. He must recover that premises. He must send me a notice to quit the premises 6 months before my tenancy agreement is expired. If he does not give me that kind of notice, that means that he must wait until he has the opportunity to give me another 6 month notice. Because of what? Because if he does not do so, the law will not give him the authority to recover that premises from me. Because of what? Because at a particular moment in time, our tenancy might still be subsisting, one, and at the same time, I will pay him. He cannot just come into the building and evict me out of the building. No, there must have been quit notice. And the quit notice that it might have served me if, for example, I have just 3 months left for my agreement to be for my tenancy agreement to expire. I now is now giving me 3 month notice 3 months before my yearly tenancy instead of that of 6 month notice. That notice is not valid under the law, and he cannot use that as a basis of my eviction from the house. So he has to wait on he have another opportunity to issue me 6 months quit notice. But in the case of maybe me, I'm unable to pay him after my tenancy has expired and I still remain in that house, I become a statutory tenant and he is entitled to give me 7 days quit notice from the house. But if I still stay in the house with the consent of the landlord, I still have the right under the law by the tenant by the landlord to give me 7 days quit notice before I can be evicted out of the house. Because after the quit notice have been issued, the law says that the tenancy has been determined, and that ends the relationship between landlord and tenant. What is next is that the landlord will just recover the premises from the tenant. And how will the landlord recover the premises from the tenant? Always should be by a court order. It should always be by a court order. You cannot just go into the house of your tenant and start packing out his loads. it is not allowed by the law. It is impermissible. It is impermissible. You cannot do such. The best that you can do is for you. The best that you can do is for you to what? To go to the court and seek a court order to what? To recover your premises from the tenant. And the third thing is that once a landlord has seen that the tenant is holding over and is not willing to pay rent anymore, what should the landlord do at that particular moment? Under the situation, the tenant will be indebted to the landlord. He will be owing him some money. But we have just said that the tenant still have the right to be living in that house. Does that mean that if the tenant have the right to be living in that house, does the landlord also have the right to collect rent at that particular moment? Yes, the landlord have the right to collect his due rent at that particular moment in time, but it will be through the court. It is the court that will order the tenant to pay that money. That money after the tenancy has expired till the time that he leave the house, he must pay the money. And this money that he will be paying at this particular moment in time is what is called means profit. Means profit is the money or the profit that is accrued to the landlord during the time that the tenancy agreement has expired up till the time when the tenant is giving up the premises to the landlord. Let's say, for instance, I rented an apartment from a landlord and my tenancy agreement has expired since January and I'm still in the house up till now. I've paid before I move into the house, but from January to this to up to this month, I've not paid any money. That money from January to this month that I've not paid, if the court will now order me to pay it, it is what we will now be calling means profit. And means profit is a kind of compensation or damages paid to the landlord at a particular after the tenancy agreement has expired to the landlord for him to recover from the break, maybe the break of agreement between them or any other thing of such nature. Now, these are what the landlord should do. And immediately after the landlord is seeking for the means profit, he must also seek for the recovery of the premises. And then after the court has ordered the tenant to pay means profit to the landlord, at the same time, it has ordered the tenant to give up the premises to the tenant. Okay, shikina, it has been done. Now, if the court order has been issued and the landlord still remain adamant, still remain stubborn in that house, all the means can be used legally under the law to enforce the judgment and to force the tenant out of the premises. These are what it should be done. But as regard the means profit, the landlord must not sleep on his right. He must approach a court of law and make sure that he he, he claim the sum of the money within 6 years. Because if he doesn't do that within 6 years, the tenant might later come back and be pleading limitation law, because there is something called limitation law under the law. Limitation law under the law, it gives limits to some kind of course of action, to some kind of situation by which within this year you cannot approach the court again to seek this kind of right. So after that, after the expiration of 6 years, the right of the landlord to recover means profit, to recover that money from the tenant, will be extinguished, will be cancelled, will be null and void, and will not be available to the landlord ever and ever again. So all these ones must be taken notice of. And the best thing to do if you see that your landlord, you as a landlord, your tenant is trying to be stubborn, is that just approach a lawyer and the lawyer will know what to do. Approach a lawyer of your own choice. The lawyer will know what to do. If you don't approach a lawyer and you are just doing it on your own self, well, the result is also on you. But if you know all these things, or if you know that all these things can still be done, all these things are still available for you, the best thing for you to do is to what? is to go to where it will be taken, it will be done effectively for your own benefit. I will have to stop here for today, till next week that we shall come here again and continue our lecture. Abdullah Adebayo Abrof is my name, and this program is being brought to you with the sponsorship of Ajisibo Yolan and TV and that of Abdullah Legal Academy. Abdullah Academy is an initiative that caters for the termination of law, the knowledge of law, especially the rights that people have under that law and how to seek redress, how to enforce those rights. And at the same time, organizes result driving law tutorials for law students across various faculties of law in Nigeria. And there are so many things that we have been doing for us to be able to achieve these two aims of ours. Before I end the lecture for today, I would like to inform you now that if you want to create a video, maybe an advert for your product, or a documentary video for your event, or an animated flyer for your event, or anything that is related to video, anything, just anything, you can contact me directly. You can reach out to me directly on my phone number, which is 09034904883. 09034904883. And also, if you want to learn video editing and video creation, you can also reach out to me on my phone number that I just mentioned earlier. So before I end the program for now, I would like to check under the comment section on our Facebook to see if there is any question or questions. And if there are no question or questions, I would like to stop here for today, and at the same time acknowledge those that. Okay. I've okay. I've been seeing the hand of the engineer here. Okay. No question or questions here. So I will be stopping here for today by the special grace of God till next week that you and I shall be meeting here again. Do have a wonderful legal day ahead.